Hello, friends. Recently, we saw the finance minister presenting budget 2022, making very interesting announcements on policy and taxation so far as India is concerned. One very interesting observation and an announcement which the finance minister made was in terms of implementing and coming up with a cross-border insolvency law as far as India is concerned. As you know, we got our insolvency and bankruptcy code in late 2016, which has been a paradigm shift the way we see restructuring and liquidation process implemented for Indian businesses. It was a important step towards not only making businesses thrive in India, but also making sure that when things go down south, there is also robust mechanisms to either restructure or liquidate, because that is also important from a perspective of any business, any jurisdiction is concerned. Now, with that announcement of bringing cross-border insolvency law, there are obviously important questions which still remains unanswered. So, Arjun, what is your initial take on this? What is your thought process about this announcement?
Thanks, Vyapak. I think it's the need of the hour and almost long overdue that India has a cross-border insolvency resolution framework institutionalized and given the force of law. In the past 5 years, when the IBC has been in operation, there have been multiple such instances where an Indian company is undergoing insolvency resolution and many of its valuable assets are placed outside in different various jurisdictions. And in all of those cases, the NCLT, along with the resolution professional, has had to devise an ad hoc method to deal with those kind of situations. Case in point would be Jet Airways or Videocon Industries. And with the implementation of this framework, we will have a lot of clarity and comfort to the international community that in case there arises this kind of a situation, their interests will be well taken care of.
Sure. So, what is the current position? Because a lot of people talk about cross-border insolvency from an Indian context since its inception in late 2016. So, what is the current position?
So currently, unfortunately, the insolvency code does not have any process prescribed to deal with this kind of a cross-border situation. But in late 2018, the Insolvency Law Committee had provided a report where they had proposed the adoption of a model law, which was based on the ancestral model law for cross-border insolvency resolution. Basically, the idea and the objective of this model law is to promote cooperation and coordination between not just the resolution professionals and the creditors of two different jurisdictions, but also the judicial authorities. This will effectively ensure that if there is a cross-border insolvency resolution situation appearing, then either the assets situated outside are being utilized to pay the Indian creditors, or an Indian resolution proceed is being distributed with a foreign creditor. So, however, obviously, as we have seen in the past, that the IBC has been suffering from some issues of implementation, which is common with any nascent legislation. Most of these are interconnected because there are certain interpretative issues to the IBC, which have gone through lengthy judicial discourse. So we hope that this framework doesn't suffer from a same fate.
Sure. No, we have seen instances like Videocon and Jet Airways in the past, and the ad hoc way of in those situations. And also, as you rightly said, the framework or the guidelines was issued by the government in late 2018, early 2019, and there was some consultation at that point in time. But I hope similar consultation as well happens at this point in time to take into account what are the situations to be taken care of before implementing such law. So maybe one or two very specific asks or demands that you may have for the lawmakers.
Yeah, so maybe a couple of quick points, which would be one, that giving too much discretion to an adjudicatory authority to deliberate on whether a process should or should not start would generally lead to delays through litigation. So something like public policy of India, which has been dealt with by the judiciary under the Arbitration Act, these terms not being defined in that framework could cause judicial delays. They can be better defined. Again, the requirement to ratify the model law and thereafter reciprocity should be streamlined right from the word go, rather than first implementing it and then taking it slowly and getting the countries in at a slow pace.
Sure. No, I think it is very important to have a robust cross-border insolvency law, because not only in today's world that assets are outside the jurisdiction in which the company is going through the insolvency process, but there may be litigations, there may be other issues where those jurisdictions, if they don't comply with the moratorium or otherwise, or deal with the asset or deal with the litigation in a different way, then the whole restructuring can go haywire from the perspective of the jurisdiction like India, who maybe wanted to implement a robust restructuring process. So, bringing Ashish in this discussions and, sitting in Singapore, Ashish, you are looking at, global developments so far as insolvency and restructuring law is concerned. What is your take on this announcement?
So obviously, Vyapak, I think a regime for cross-border insolvency in India has been asked for a long time. And Finance Minister announcement now gives us some surety that we will now see it happen within the coming financial year. In Singapore, for example, again, like in India, actually, in that way, but slightly different. In 2018, Singapore also passed a completely new law for their insolvency regime here, which actually came in force in the middle of 2020. That is like literally the beginning, or let's say near the beginning of the pandemic. And the new law is fairly interesting because the aim behind the new law is to make Singapore an international hub for debt restructuring. And it actually allows foreign companies with connections to Singapore to be subject to the Singapore's insolvency regime. And equally, Singapore is also a signatory to the the UNCITRAL cross-border insolvency law. Or sorry, Singapore adopts the UNCITRAL cross-border insolvency law. So it would be interesting to see once India brings in their cross-border insolvency law, and assuming Singapore is recognized, which we hope and believe it is, as a reciprocating territory for the insolvency regime, how would that interact with the Singapore's cross-border insolvency regime and its laws, particularly where an Indian company looks to make benefit of the Singapore's new insolvency laws and debt restructuring provisions?
Yeah. No, I think it's a very interesting development that we are going to closely monitor as we go forward. We as a firm will definitely participate if there is any further consultation on this law, and provide our comments. And in that regard, we would expect and we would invite comments and suggestions from everyone who is seeing or listening to this video, and incorporate them when we make our representation. So please keep a watch on this space going forward, and we'll keep updated on what's happening to the announcement on development of cross-border insolvency law as made in the recent budget presented by the Indian Finance Minister. Thank you all for listening to this video. Thank you.
Thank you.